Swayam Prabha. Digital India. Educated India.
Dear students, in this class we will discuss the unilateral refusal to license or deal, whether I have a right, if I am a producer, whether I have a right to unilaterally refuse to license or deal with anybody. So, you will say that in contractual law, in contract law, you are free to contract with anybody, you are you can very well refuse to deal with somebody. But the question is, in the case of intellectual property rights, whether you have that right, you have a bundle of rights given through the intellectual property, but the state is given that particular right is whether it is an absolute right. In the previous classes we said that intellectual property rights are not absolute rights, it is subject to restrictions, it is for the betterment of the society. When it comes to the intellectual property versus competition law, this intellectual property should be used only for the purpose, for the benefit of the market, benefit of the society at large. So, in this class we will see the monopolization of service market, how some of the companies are monopolizing service market and how the competition law is taking care of this. Then tying, which we already discussed, but the tying of service with the product is also one of the problems, and we will see that how the competition law is taken care of this monopoly or a monopolist, with the monopolist which is dominating the market with his technologies. A new doctrine came, which is the essential facilities doctrine. If I refuse to license, if I refuse to license on reasonable terms, then what the authorities can do under the essential facilities doctrine, we will see this. So, unilateral refuse definitely and I am refusing to license it on maybe due to the business reasons, maybe due to market reasons, maybe due to other reasons. So, here market power is most important thing. So, market power is can control the market absolutely and dominate the market, and also which can increase the profitability of the company and control the output as well as the control the competitors in the market for a significant period of time. So, and here you can see that how these patents, copyright or trade secrets, whether they necessarily confers market power upon its owners. Unfortunately, the intellectual property law never confers market power, but because of these intellectual properties, some of the big companies and mostly the knowledge driven companies, they dominate the market. And in that particular case, what is the situation? How the competition law is going to deal with this kind of situation? So, as I told you, the concept of antitrust itself is to open up the market, and the market should be benefited, and the market the consumers should be benefited out of the technological revolutions and innovations. Even though the technology is illegally acquired or maintained, if it is legally acquired or maintained, then always there is an eye of competition law on that particular technology. So, here the question is whether the intellectual property owner, I acquired the intellectual property legally, have the right to harm the competition in the market. So, that means my unreasonable interference, my unreasonable conditions are going to affect the market, whether I have that particular right. So, but we can find a number of cases where the court said that I am the owner of the intellectual property, the owners of the intellectual property do not have any right to exploit the intellectual property in such a way to affect the market. The famous case of 1994 case of Data General Corporation versus Grumman System Support. Here the two companies, so mostly the software companies in the 80s, they fight each other for the market, because the softwares and the technologies were developing at that particular point of time. So, in this particular case, you can see that the Grumman uses a complex computer program, so which is known as the edX. So, the complex the computer program which is developed by the Data General Corp to diagnose the problems of computers, the problems in the DGs, the Data General's MB computers. That means, one produces the computers and the other one is the service provider, which is using a software to identify the problems in computers. Here the Data General, they claim that the Grumman infringed DG's the copyrights and misappropriated trade secrets embodying in edX. And if you look into this particular case, the facts of this case, and it is very clear that the Grumman systems and their operators and their service personnel has widely used this particular software, which is owned by the copyright is with the Data General during its services. So, here you can see that if the intellectual property which is acquired through the copyright, the component of copyright intellectual property which is owned by the Data General has absolutely violated by the Grumman systems when they are servicing the computers. So, the district court awarded damages, and what this upper court said here, the Grumman is arguing that. So, the DG is illegally maintaining its monopoly power in the market for service of the DG computers. So, it is not only they have, I also must get a pie of that particular service. So, unilaterally refusing to license this edX, that is the particular software which is used to identify the problems in this particular computer, and the Grumman alleged that the DG is refusing to license this particular software to not only Grumman, other competitors as well. So, it is a violation of competition law. But if you closely look into this, see, I am the copyright owner of a particular software which I developed for a computer, and these are protected by intellectual property, and it is whether to license or not to license, it is with me. So, the question is whether you have the complete right, can you refuse it to license to anybody else? This is the particular question. So, this software is very necessary for repair of these computers as well. So, here its allegation was that the DG misused and they tied this particular software with their computer services. So, the agreement, and also they said that the consumers agreement either to purchase DG support services or not to purchase support from third parties. Whenever they sell their machines, and they said that you should take the service from me, support services from me, and also not to take any third parties. So, in this particular case, you monopolize the product, you monopolize the services, and you do not allow anybody else to do the services as well. So, other business people will be completely out of the purview. So, here the refusal to license, the court very clearly said that here it is absolute refusal to the license. So, which is violation of the Sherman Act, and then again this particular company is a monopolist. It's completely excluding, constituting an exclusionary conduct of everybody else. So, exclusionary conduct, the question is exclusionary conduct is whether is affecting the market. Here the single company, it is a monopolist who is controlling the absolute market as well as the services. So, all other people will be out of business. So, it means the refusal competitive process, a monopolist once started harming the competitive process in the market, then it is a violation of competition law. For example, the earlier decisions in Aspen Skiing Company, and also is if you do not have a valid business justification for tying these two, then is going to be a violation of the competition provisions. So, legitimate competitive reason for the refusal must be given by the companies. So, otherwise, but unfortunately, in this particular case the court held that these companies are monopolist and violation of the competition provisions. Here what do you mean by business justification? Business justification is a valid justification, it must be relates directly or indirectly to the enhancement of consumer welfare or competitive process in the market. Then only you can claim that it is a defense of the competition provisions. So, it means that if that particular process is for the pursuit of efficiency and quality control, that might be legitimate competitive reasons. It is not going to attract the competition provisions, otherwise the competition provisions are going to attract. And also the court in this particular case held that this exclusionary conduct of all others and to include a monopolist unilateral refuses to license the copyright, and then again others desire to exclude others from use of its copyrighted work is a presumptively valid business justification for any immediate harm to consumers. So, there is no harm if I am keeping that particular product as well as the copyrighted product, the software, provided if the market is not going to affect. But if the market is going to affect and the competitive process in the market is going to affect, there may be a higher price also. So, then the provisions of the competition provision is going to visit that particular action. Here you can see that. So, effective competition cooperation is indispensable to the effective competition in the market. So, you have to cooperate with even with your rivalries. So, service, if you look into the service market, so Eastman Kodak, many times the Eastman Kodak cases comes. So, image technical services versus Eastman Kodak 1997 case. Here and independent service organizations of Eastman Kodak sued actually the Eastman Kodak for under violations of the provisions of Sherman Act. So, here the Eastman Kodak, this was with regard to their photocopy machines and micrographic equipments. So, here also the machine is tied, the allegation was that the machine, the photocopy machine is tied with the post sale services of photocopy machines. Here you can see that at that particular point of time, the Kodak repairs 80% of the machines they manufactured by them. So, that means, so 80% of the machines, even though they do not manufacture 80% of the machines, but the service market is controlled by the Kodak. Here and also they what they simply said that in the 1980s the Kodak restricting access to its photocopier and microcopy parts. They simply said that we are not going to sell the parts to independent service organizations. So, what is going to happen if you do not have parts, spare parts, you are going to be out of the business. So, the Eastman Kodak taken a decision not to sell spare parts to the independent service organizations. So, it means they are going to kill the competition in the market and to take over all the services of these photocopy machines by Eastman Kodak themselves. So, these service providers does not have access to parts. So, once they does not have the access to parts or there is a deficiency in the parts, so these independent service organizations will be out of business. And here so they allege that there is a violation of section 1 of the Sherman Act. And secondly, we can see that, so this is an attempt by the Eastman Kodak to monopolize and attempted monopolization of sale and service of Kodak machines. This is also violation of the Sherman and Clayton Act. So, actually the district court gave the judgment in favor of Kodak. So, because they have the copyright, so the court thought that actually the court thought that you have the machine as well as the service which is protected by intellectual property law. So, there is no violation at all, but here the independent service organizations were awarded damages, because you are making the product tied with the services and absolute monopolist is formed by that, and you can increase the prices to whatever you want in a particular situation. Here the case is the higher courts which was awarded the damages to the tune of 71 million US dollars. So, it is it's very clearly the court said that the Kodak objective is to monopolize the market, not only the product market as well as the service market. And also the court ordered the Kodak to supply the parts for next 10 years, independent supply, independent service organizations for a period of 10 years, this particular product on reasonable and non-discriminatory terms and prices. This is very important, because even though I am a monopolist, I am not permitted to sell any products on discriminatory terms and prices. And here specifically, it is the court said that all tools and devices essential to servicing Kodak equipment must be sold for, which must be made available to the independent service organizations for next 10 years. Here the monopoly, as I told you, the Kodak was actually trying to create a monopoly market not only in the product market as well as the service market, which was the court held that, which was against, it is going to affect the competitive process in the market as well as the competition provisions, the Sherman Act, violation of Sherman Act, which was proved in this particular case. Then we come to the essential facilities doctrine. This is very recent in origin. If the technology, newer technologies comes into play, and because innovative technologies, for example, the mobile phones. The mobile phone is, I would say that it is a bundle of patents. Thousands of patents are in a mobile phone, which are owned by different companies. So, if a company, for example, Ericsson, if Ericsson is refused to license this particular new technology to Indian company or Chinese company or any other developing country companies, what the developing countries will do for manufacturing a lower priced handset, mobile handset. So, this is the concept. In such situations, remember all these technologies are protected by the intellectual property rights. So, what you are going to do in this situation? In this particular situation, the court considered the case of Intergraph Corporation versus Intel Corporation. So, here you can see that Intergraph is the original equipment manufactured with Intel microprocessors. Intel, everybody knows that the microprocessors are used in each and every equipment. So, here Intergraph used a particular technology in computer workstations during the 1987 to 96. If you look into the facts, so 87 to 93 they used this particular technology. In 1993, Intergraph discontinued this clipper technology and switched to Intel microprocessors, and there is a very warm relationship between these Intel and Intergraph, and they cooperated each other, and certain concessions were given to the Intergraph Corporation up to from 1993 onwards. In 1996, Intergraph charged several Intel original equipment manufacturers and customers with infringement of clipper based technologies on Intel microprocessor. So, 3 years from 1993 to 1996 the relationship was good. In 1996 this Intergraph the terms were changed between these two companies, and they started suing the original equipment manufacturers. In 1999, Intergraph sued Intel for infringement of the clipper patents, the clipper technology which was earlier used. And see, of course, the two companies, their relationship can be good, and after some time their relations can be bad, but intellectual property violations are intellectual property violations. And here the question was, Intel is a monopolist. So, certain benefits were given to this Intergraph was withdrawn by Intel, because the reason was that Intel said that you are filing anyway, you are filing suit against me, why should I give you any kind of benefits. So, Intergraph said that these withdrawal of benefits are violation of section 1 and 2 of the Sherman Act, and they cited the another very old case of 1912 US versus the Terminal RR Association, the Rail Association. So, here you can see that the association was controlling at that point of time all railroads, terminals, bridges and yards and all the facilities to competing railroads. There is no competition at all for others. So, in this particular case it was said that this railroad association was controlling the entire business. So, it is a violation of the Sherman Act. So, they cited this particular case as well. So, here comes the essential facilities. So, if you think that this particular technology is essential for manufacture, it is essential for manufacture of a particular product, and the owner of the intellectual property refuse to license, then what you will do? Here, as I told you, it is necessary. It is necessary to compete in the market. Here, so it is very clear, in order to apply the essential facilities doctrine, the facility must be controlled by one firm, and there is an obligation to make facility available to non-discriminatory terms to everybody. So, the essential facilities doctrine, which facilitates the licensing of these technologies, this facility to even to the competitors, so that there is a fair competition in the market of newer technologies. Otherwise, the new technologies will be only given to certain people, those who can pay more, and the developing countries will be out of technologies. So, but certain conditions to be fulfilled for applying these essential facilities doctrine. First of all, the control of the essential facility must be with the monopolist, and secondly, the competitor's inability practically or reasonably to duplicate the essential facility, and thirdly, the denial of the use of the facility to the competitor, and fourthly, the feasibility of providing the facility, and fifthly, so if you are using that particular technology for eliminating the competition in the downstream market, then the essential facilities doctrine will be applicable to your technology, and it will be given to others on reasonable and non-discriminatory terms. So, essential facilities doctrine clearly which facilitates the others to get a license of an intellectual property on technology. So, this refusal deal may arise when the antitrust concerns. Refusal to deal may always raise the antitrust concerns. That is also the refusal is directed against the competition, and the purpose is to create, maintain, enlarge, and to create a monopoly or a monopolist, and then is definitely the provisions of the provisions of the Sherman Act is going to be attracted. Here the Intel is a big company with microprocessors, has engaged its coercive measures to agree to the terms and conditions, and which uses, because the Intel microprocessors are used in every technology. So, coercive reciprocity. So, if you do it, then only I am going to give you my technology. So, this is pernicious effect. This is a pernicious effect on the market, on economic similarity. So, this is nothing but illegally tying cases. So, definitely it is going to affect the market. The court said that it is a violation of section 1 and 2 of the Sherman Act. Then again, this kind of coercive reciprocity is by using intellectual property is restraint of trade and violates ultimately the antitrust law. So, no company can use coercive reciprocity as a technologist, the owner of a higher technology, I cannot refuse it, because the essential facilities doctrine will be used and others will be made available to it. So, refusal to deal, as I told you already, technology very clearly, now the newer technologies are available, and the all players in the market should be made available to the newer technologies. If you are refused to deal with these new technologies, then the essential facilities doctrine is going to be the doctrine is going to be applicable to in such cases, and these technologies will be made available to such kind of peoples on reasonable terms, on fair terms and non-discriminatory terms. So, even I have a higher technology with protected by intellectual property, it is not my sweet will to give or not to give. So, I cannot refuse that particular technology to my competitors, because this is very essential to keep the competitive process in the market, as well as competition in the market, and the competitors also can survive by this. And we will see in the next classes the continuation of these classes how the intellectual property interacts with competition law through the number of cases decided by the US courts. Thank you.